Welcome to this explainer. Today we're diving deep into the fascinating and honestly pretty complex evolution of digital evidence admissibility in the Indian judicial system. Whether life, liberty, or a massive multi-million-dollar business dispute is on the line, the final verdict often rests entirely on a single digital file. Okay, let's jump right in. Because if you're dealing with law, investigations, or really just how truth is established in the modern world, the rules of the game have completely changed over the last 2 decades. To really understand our digital evidence laws, we first have to ask this absolutely crucial question. How exactly do you prove that a server log or a WhatsApp chat is an original document? For centuries, the law relied on the traditional common law concept of an original. Think of a physical piece of paper with a real ink signature. But electronic records, they just do not fit that mold. And this gets right to the heart of the problem. Unlike a signed paper contract, a digital file, like a WhatsApp chat or a computer log, has no single physical original in the traditional sense. It's literally just a series of ones and zeros. Because of this, it can be duplicated, forwarded, or completely modified without leaving a visible smudge or an erasure mark behind. This fundamental difference meant we desperately needed a completely new legal framework to ensure that what's presented in court is actually the truth. So here's our roadmap for today. 1. The old evidence regime. 2. 15 years of court battles. 3. The new dual certificate law. And 4. Securing the chain of custody. All right, let's start with Section 1. The old evidence regime and solving the original problem with Section 65B. Let's rewind to the year 2000. The Information Technology Act inserted Section 65B into the Evidence Act of 1872. This was a highly specific solution to a very specific problem. Section 65B was the initial legal workaround designed to legally deem a computer output as an admissible document. This was incredibly practical. Imagine having to drag a massive, humming physical server or a witness's personal phone into a physical courtroom just to prove a point. With this, you could use the information stored or copied onto optical or magnetic media instead. But you couldn't just walk in and hand over a floppy disk. For that digital record to actually be admitted, the law said 4 highly specific technical conditions had to be met under Section 65B, subsection 2. First, the computer had to be in regular use. Second, the information had to be regularly fed into it in the ordinary course of activities. Third, the computer had to be operating properly. And fourth, the output had to derive from information fed in the ordinary course. In practice, this meant you had to prove the system itself was reliable and used for everyday business, like a company's server logging employee emails, and not just a device set up specifically to fabricate evidence for a trial. Now, on top of those 4 operational conditions, the law also demanded a specific piece of paperwork. Section 65B, subsection 4, required a single certificate signed by a person occupying a responsible position in relation to the device. This certificate had to identify the record and describe exactly how it was produced. It sounds simple enough, right? Just a bare certificate from the device owner. But as we're about to see, this single piece of paper would spark a massive legal headache. Which brings us to Section 2, 15 years of court battles, or as I like to call it, the Supreme Court's doctrinal tug-of-war. It's wild, but one single statutory phrase triggered over a decade of genuine doctrinal instability. Over 15 years, the Supreme Court actually had to step in 4 separate times to nail down exactly how strict this certificate rule was supposed to be. It all started back in 2005 with the Navjot Sandhu case. The court treated the 65B certificate as merely directory, meaning it was optional. They held that you could prove electronic evidence through general secondary evidence rules even without a certificate. But, this created a really permissive standard. Fast forward to 2014, and the decisive Unvar PV case comes along. A 3-judge bench firmly overruled Navjot Sandhu, stating that Section 65B is a complete code in itself. They laid down the law. The certificate is absolutely mandatory for secondary electronic evidence to be admissible at all. But the real world is messy, right? In 2018, the Shafi Muhammad case highlighted a huge complication. Think about it. If you need CCTV footage to prove your innocence, but the camera belongs to a neighboring shop owner who flat out refuses to sign a legal certificate, you'd be stuck. To fix this, a 3-judge bench finally settled the dust in 2020 with the Arjun Pandritrao Kokar case. They reaffirmed that the certificate is genuinely mandatory for secondary evidence. But they added a crucial safety valve. If a party is genuinely unable to secure a certificate from an uncooperative third party, the court itself can step in and direct the production of that certificate. Moving right along to Section 3, the new dual certificate law, upgrading to BSA Section 63. So the new Bharatiya Saksha Adhiniyam, or BSA, deliberately preserves that settled 2020 framework but gives it a genuinely massive upgrade. Take a look at this comparison. Section 63 replaces 65B. Under the old law, a single signature from the device owner was enough, and a hash value wasn't required at all. But now, under Section 63, subsection 4, we have a dual signatory format. Part A is filled out by the person in charge of the device, and Part B absolutely must be completed by an independent technical expert. And incredibly importantly, it now mandates a hash value.
Now, what in the world is a hash value? Think of it like a digital wax seal on an envelope. It's a unique string of characters generated by a mathematical algorithm based entirely on the file's contents. If you change even a single pixel in an image or one tiny letter in a chat, the algorithm outputs a completely different hash value, instantly exposing the tampering. This cryptographic fingerprint mathematically guarantees the evidence hasn't been altered since its initial capture. It is literally the absolute linchpin of the new law's reliability.
Oh, and here's a crucial point to keep in mind. Alongside this, BSA Section 57 explicitly extends the definition of primary evidence to digital records. So, if you can provide the genuinely primary original electronic record directly from the physical device on which it was first stored, rather than a copied derivative, you don't need this complex Section 63 certificate at all. The certificate is strictly a rule for secondary evidence. Finally, Section 4. Securing chain of custody, bringing the law into forensic reality. So what actually gives that hash value its power in court? It's the chain of custody, the unbroken, meticulously documented record of who collected the evidence, how they did it, when, and who handled it. The statutes now aggressively anchor this into law. BNSS Section 176 mandates forensic investigations, including scientific evidence gathering, right at the crime scene, for offenses punishable with 7 years imprisonment or more. Furthermore, it introduces mandatory audio-video recording of search and seizure proceedings. This video becomes part of the evidentiary record, proving the device wasn't tampered with right from the get-go. In the real world, high courts today expect investigators to follow a super strict playbook. Step 1. Use write blockers. These are physical hardware devices that intercept data commands, physically preventing a computer from accidentally writing any new data onto the seized drive. Step 2. Create a forensic image. Now, this isn't a normal copy-paste. It captures the entire physical drive bit for bit, including hidden or deleted files. Step 3. Compute and log the hash value immediately. And Step 4. Maintain a documented custody log of every single person who touches that evidence. This quote really hits the nail on the head. A break anywhere in this chain, an unexplained gap, a mismatched hash value, or an uncertified handler is exactly the kind of defect that gets evidence completely thrown out. If you mess up the physical handling, it really doesn't matter how compliant your Section 63 paperwork looks on its face, your case is going to get destroyed on cross-examination. Real quick, before we wrap up, a vital procedural note for all you legal professionals watching this explainer. The new BSAs has a crucial savings clause. It does not apply retroactively. This means all proceedings, investigations, trials, or appeals that were already pending immediately before July 1, 2024 continue to be governed by the old Section 65B regime. You have to correctly identify which regime applies based purely on when the matter commenced, not when it happens to finally be heard in court. And that brings us to the end of our deep dive into the evolution of digital evidence law in India. As we wrap up this in-depth explainer, I want to leave you with this final thought. With hash values and dual certificates now firmly the standard, are we finally equipped to completely trust digital evidence in our courtrooms? Or is the rapid pace of technological and forensic reality inevitably going to outpace even this brand new law? Thank you so much for joining me today, and keep questioning the evidence around you.